based upon, the types of jurisdiction that are there and the importance of distinguishing between them, the way states delegate their jurisdiction, their powers of jurisdiction to the ICC, and we will be talking about the special agreements of the Fourth Geneva Convention, and finally the situation in Palestine and the effect of the Oslo Accord, or as I like to call it, the non-effect of the Oslo Accord on the court's jurisdiction, and finally the approach of the pre-chat chamber dealing with the issue. And at the end, you will be given a chance to ask questions. To start with, I always tell students that the first thing to learn about jurisdiction, that in this Westphalia system, the system of sovereignty, the jurisdiction of states rests in its sovereignty, as the Permanent Court of International Justice have stated in its Lotus judgment, meaning that states are free to assert their jurisdiction, as we will see. Jurisdiction itself is the competence of the court to deal with a criminal matter under the statute. This was the definition that the appeal chamber gave in the Lubanga case. It is important to realize that the notion of jurisdiction has different types that we need to distinguish between them. The first is the subject matter jurisdiction, as we call it in Latin, retione matera. The second is the jurisdiction over persons, as it's called retione persona. And third is the territorial jurisdiction, which is the type that we're focusing on in this lecture. The fourth is the temporary jurisdiction, which is called retione temporis. Territorial jurisdiction of the court. The territorial jurisdiction of the ICC is reflected in Article 12, paragraph 2, subparagraph A. The text of the article says that the state on the territory of which the conduct in question occurred, or if the crime was committed on board of vessel of aircraft of the state of the registration. Now, the second part of the article is not of our interest. We need to focus on the first highlighted part, which says the conduct in question. And here there has been a lot of opinions by scholars what conduct means. Of course, a lot of people thought of the term conduct as the abstract act. However, the ICC position is that the term conduct is used as a reference to criminal conduct absent of legal characterization, and we will learn what that means. Now, the second point is the location of the conduct. How much of the conduct in question needs to take place on state's party territory in order for this state to be able to delegate jurisdiction to the court, in order for the court to have jurisdiction. So, in other words, territorial jurisdiction of the court is the scope of its investigation, until what limit, which part of the territory the criminal investigation can cover. Now, it is unclear from the preparatory work of the ICC why the drafter used conduct at the beginning of this article. Let me try here. Yeah, I don't know if you can see in red here the conduct in question. And in the second part of the article, they used if the crime. Now, in legal terms, what's the difference between crime? What's the difference between conduct? We know that every crime has a mens rea and actus reus, has a material element and has the mens rea, which is the criminal project or the criminal idea. Now, the conduct, it might appear as, people might think of it as meaning the conduct itself. However, as we said, the term conduct, here there is no difference. What is meant here, the more feasible interpretation for the word conduct, especially in light of other articles, that it means criminal conduct, absent legal characterization. Now, the territoriality principle is a very important concept in the ICC. One must bear in mind that during the negotiations of the Roma Statute, states, as expected, thought that the ICC wouldn't have universal jurisdiction. This is normal because states like their sovereignty and they don't want any court just to have an absolute jurisdiction in any country in the world. However, the ICC was based on the least controversial, the conventional basis of jurisdiction, which is the territoriality principle. It has been thought of by those who were in favor of the universal jurisdiction. They thought this is a disadvantage of the court. However, the way that the statute is drafted, the way that there is constructive ambiguity in the wording of the statute, has left room for the court itself to decide. For example, the issue of jurisdiction has been decided in the Myanmar Bangladesh case, and for me this is a landmark decision because it was the first decision that the court explicitly stated that the court should have jurisdiction if any part of the crime committed on the territory of the state, meaning that it does not mean that the whole crime need to be committed in one state. Only if one element of the crime, then the courts would have jurisdiction. It has been argued that this is an expansive approach of the court's jurisdiction. However, the court was very cautious when it expanded or interpreted its status in this way, and we will explain how. First of all, the meaning of the territorial principle is that states have the right to exercise jurisdiction over any parts of their territory. It's their absolute right. What is more interesting is that customary international law imposes no restrictions on states in asserting their jurisdiction. That's why you see the jurisdiction basis for states are different. The way they assert their own jurisdiction are different. In Europe, for example, you will find states who adopt the universal jurisdiction, meaning even if none of the elements were committed in the country, still the country could actually prosecute for such crimes. However, what the court tried to explain that whatever the limits of the territoriality principle in customary international law, those are the limits that the court would be bound of, and only those. Therefore, the idea is that if the states normally have the right to assert jurisdiction if there is any link to their territory, the International Criminal Court should have this authority as well if there is a link of a crime in one of the territories of its state parties. Now, I would like to explain briefly how states usually assert their jurisdiction. First, if the crime is initiated abroad but completed in its territory, in the state's territory, this is called the objective territoriality principle. Second, if the crime has been initiated in its territory, in the state's territory, but completed abroad, and this is called subjective territoriality principle. Third, if part of the crime took place on the territory, irrespective of whether that part is a constitutive element of the crime or not. And now, later we will know why, because there's another theory that is only about the constitutive element, other than the ubiquity principle. Here, if at least one constitutive element of the crime occurred in its territory. And the fifth is if the crime takes place outside the state territory, but produces effects within the territory of states. And this has been called the effective doctrine. Its origin, ironically enough, its origin is from the US. Types of jurisdiction. And this is a very important topic when you study the International Criminal Court's jurisdiction. The International Criminal Court is a mixture. It's a mixture between international law and criminal law. And when I say criminal law in its national, or if it's in its domestic form, the way you practice criminal law at an International Criminal Court, in a way, it's not that different than criminal law in domestic legal systems. It's the same way. You have crime, you have elements of crime, and if all elements are met, the crime is established. That's why the concept of jurisdiction needs to be understood as it is for states in their domestic systems, simply because the court does not have a new invention of jurisdiction. The jurisdiction is delegated from the states to the court. In a way, the court is able to practice its jurisdiction the way its state members can do. To go back and see, those 5 ways are the ways that the court could depend on and still being within the territoriality principle. That's why this approach, when the court explained and elaborated on the issue in the Bangladesh Myanmar case, it has been thought of as an expansive approach. And in my personal point of view, I see it as a matter of fact, this could be considered as almost as a quasi-universal jurisdiction, simply because considering the number of states, at the ICC there is 123, 124 states. Considering the number of states and considering that if there is any link to any states, the courts might have jurisdiction. At the end of the day, it would appear as the court would almost always have jurisdiction, because it's very hard to have an armed conflict that does not produce effects on other states. Now back to the types of jurisdiction. First, we have jurisdiction to prescribe. And this is the capacity of a state to make its law applicable to the activities, relations, or status of persons, or the interest of persons and things, meaning the ability of the state itself to make law, to say, here's a law, I prescribe this law, and my citizens should follow. This can be extraterritorial, meaning, for example, if a country is occupied, the occupation alters this country's sovereignty, but it doesn't end it. The occupation would always be thought of as a temporary issue. The sovereignty of the occupied states remains, and even in international humanitarian law and laws of occupation, the government of the states would still be the competence government, the government that have the sovereignty and the ability to practice sovereign rights, even if in exile, meaning even if they're not present on the country itself, they're living in another country, they will still have the ability and the right to practice sovereignty rights. The second type is jurisdiction to enforce, and this means the regulation of the state's power to enforce and compel compliance or to punish non-compliance with its laws or regulations. In a way, this comes as a second step after the court prescribes its jurisdiction and tells its citizen, this is a law, you cannot do this. If you did it, I can punish you. And here comes jurisdiction to enforce. If the states have this power to be able to compel and enforce its laws, this is exclusively and typically territorial. States can only force their own laws in their own territory. Now, Now we will see why it's important to differentiate between those two types. It's important to notice that other authors, other scholars of international law have the opinion that there is a third type, which they call jurisdiction to adjudicate. And a lot of scholars, including myself, I don't believe that this is an independent type, simply because it can be considered part of jurisdiction to enforce. Because enforce or compel compliance, it can also include adjudicate, when the ability of, or the power of a state to establish a court, it's part of the enforcement of its laws. However, I'm just making this point so in your readings, if you saw jurisdiction to adjudicate, don't think that this is something new. There is a lot of scholars who think this is an independent type of jurisdiction. Now, the important issue here to realize that, again, the way that the court have its jurisdiction, it's when states delegate their jurisdictions to the court. It's in a way that states would tell the court, okay, crimes have been committed in our territory or have link to our territory in one of the 5 ways that we said, depends on how the states usually assert its jurisdiction. And then the court would take over these powers and practice it on behalf of the state. Therefore, for the court to be able to practice those powers, the delegation of those powers from the states to the ICC needs to be accurate. In other words, the state needs to be able to delegate its jurisdiction. Therefore, here in this issue, as I mentioned, it's important to distinguish between sovereignty as a concept, which states enjoy, and the exercise of sovereign rights. Again, occupation might alter sovereignty. It doesn't end it. It remains in the hands of the state, the occupied state. And this what we mean by exercising sovereign rights. Although a state may here's the point. State may continue to be sovereign, even though important governmental functions are carried out on its behalf by another state or by an international organization. By another state, think of occupation. An occupation, actually, in international humanitarian law and laws of occupation, gives the occupier the power, some powers, to practice on behalf of the occupied states until the end of occupation. This notion means that the originality of those rights remain for the states, but the occupation practices on behalf of the states temporary. Same for international organizations. The original power is for the state itself, but it delegates it to the court. Another thing we need to understand that the right, and you could consider of this paragraph which I quoted from Shanai, who is an Israeli professor, ironically enough, he eloquently describes jurisdiction, saying that the right to delegate jurisdiction is reflective of an internationally recognized legal authority and not the material ability of actually exercising jurisdiction over either the territory in question or over certain individuals within or outside the territory. And this is very important to realize, that the right to delegate jurisdiction is not about if the state is actually being able to practice these rights, simply because occupied states would not be able to do so. There is not one occupied state who enjoys full powers or can practice its sovereign rights fully in its territory, simply because there is foreign occupation. Therefore, the ability to delegate jurisdiction, it's not the material ability that you can enforce or that you can compel or punish non-compliance with your laws. No, it rests in sovereignty, meaning the ability to prescribe and issue laws in the state. Now, since we start talking about occupation, it is important to realize that the Geneva Conventions, or the writers of the people who participate in the negotiations of the Geneva Conventions, which, to be honest, I advise any students who are focusing on international humanitarian law always to read the preparatory works or start with a commentary. It can lead you to understand the atmosphere, how those treaties were conducted, because usually it's a diplomatic conference. There is diplomatic delegations that, in a way, they're representing their states. They're representing the concept of sovereignty. And on the other hand, you have lawyers and legal scholars who are trying to keep the right thing, the right legal rights and obligations. In the Geneva Fourth Convention, Article 47, it stated explicitly that in relation to special agreements, protected persons who are in the occupied territories shall not be deprived in any case or in any manner whatsoever of the benefits of the present convention. Now, the convention was made to protect people in the times of war, protection of civilians. In other words, protection of civilians under occupation. And the writers of the convention, as they thought that it might be possible one day that an occupying power, a government, would compel the occupied people to conduct an agreement that might deprive them from their right. That's why the text came in this way. Nor by any agreement concluded between the authorities of the occupied territories and the occupying power. Meaning that even if the occupying power and the occupied people conducted an agreement, and this agreement deprived or affected the rights of the protected people, then it's null, because not any agreement can deprive protected persons from their rights. And of course, annexation or extending sovereignty is the same issue, and this is the case in Palestine, which we will be talking about shortly. Now, as a conclusion for this idea, we can say, although the Fourth Geneva Convention allowed special agreements, it affirmed that such agreements cannot violate peremptory norms, nor can they deprive or deny protected persons of their rights. So special agreements are allowed as long as they do not deprive or deny the protected persons of their rights. Now, to speak about the situation of Palestine, I was actually doubting. I don't know what background you have, but I will try to give a brief chronological timeline of the procedure at the ICC. And I think this is important to understand how Palestine approached the ICC from the beginning, step by step. In 22nd January 2009, after the first Israeli aggression, Israeli war over Gaza, the Palestinian Minister of Justice submitted a declaration by Article 12.3, which is a clause where non-state parties can voluntarily accept the court's jurisdiction. Now, at that time, Ocampo, the prosecutor of the ICC, thought that the ICC is not in a position to decide if Palestine was a state or not. Therefore, they did not accept the declaration. Now, it is important to notice, though, that the way that the prosecutor explained their position, they made it abundantly clear that if Palestine wants to join the ICC, Palestine must be recognized as a state first. And the prosecutor drew a line, even showed the Palestinians the way, saying that if the General Assembly would recognize Palestine as a non-member observer state, Palestine then could accede to the Rome Statute. Now, another important step is in 2011 when Palestine obtained full membership at the UNESCO. It is important to notice that right after, in opposition of this decision, uh, uh, Israel and the US withdrew from the UNESCO and stopped funding. Now, after that, Palestine applied for the non-member observer state position, and this has been thought of correctly as an upgrade. Palestine was just an entity observer, and this United Nations General Assembly resolution have given Palestine the title state. Therefore, Palestine was able to sign the Roma Statutes. In the 1st of January 2015, Palestine declared its acceptance to the ICC jurisdiction since 13th June 2014. One might question, since 2012, and Palestine was trying since 2009, then 11 was obtained membership at the UNESCO, and then 12 got the resolution. Why did they wait for 3 years? And not to make a referral, just to make a declaration. In this period, to be honest, in a way, the Palestinian used the ICC as a leverage, in a way that they even admitted in some of their interviews. Some Palestinian leaders said that there has been negotiations over an agreement. If Israel would release Palestinian prisoners who were captured before Oslo, 1993, then Palestine would refrain from signing the Rome Statutes for 9 months. And this is what I describe in my article, saying political expediency. Of course, the court saw that, the court understand that. And we will get to the point why I think this is normal. Simply because any situation at the ICC would be politically fraught. Any position at the ICC, even the prosecutor herself acknowledged that anything she would say or do as prosecutor of the ICC would be politically sensitive, because we're talking about international criminal law. We're talking about international crimes. We're talking about states, high-ranking officials who committed those crimes, and mostly those persons are political, are leaders. Next day, as usual, the accession to the Roman Statute was sent to the Secretary General, and Palestine became officially the 123rd state party to the Rome Statute. 6th January, Palestine accession was notified by the Secretary General, acting in his capacity as a depository. And this is an issue that I talked about in another article in relation to statehood. This is important to keep in mind, but this issue is, let's say, for another time. 1st of April, Rome Statute officially entered into force for the state of Palestine. In May 2018, Palestine made a referral by Article 13A and 14. Now, Palestine waited another 3 years. It is important to note that since 2009, the prosecutor started a preliminary examination. Then he concluded Palestine cannot be state. Palestine went to the UN, became a state, then came back to the court, made another 12-3 declaration, and then waited for 3 years of preliminary examination, and the prosecutor did not conclude her preliminary examination. There was no results. Then Palestine made the referral. This is important. Why? Simply because if Palestine waited for the prosecutor to conclude the preliminary examination and start an investigation, the prosecutor would have to ask for permission from the trial chamber to start an investigation if it was based on 12.3 declaration. But if the referral was made by Palestine, the prosecutor does not actually need to ask the court for permission. That's why she made it clear in her statement that she does not have to ask permission from the court. By law, she has the right to start an investigation proprio motu, as they say, immediately. But she went to the court and asked an important question about the scope of its territorial jurisdiction, which is, again, it's not a question if the court has jurisdiction or not. The prosecutor believes that she has jurisdiction. She could also start an investigation of herself, but she wanted to be sure of what is the scope of its jurisdiction, which territories that she can cover and which territories she can't. In 20 December, this was the conclusion of the preliminary examination, and then seeking a ruling on the scope of the court's territorial jurisdiction, which will be soon enough, probably in the coming 1 or 2 weeks. We will hear the ruling of the court. Now, the Oslo Accord as special agreement. Now, this is the issue that is important in the Palestinian situation. First of all, to give you an idea, the Oslo Accords was an interim agreement, meaning it was an agreement that was limited to 5 years. It was conducted between Israel as the occupying power and the Palestine Liberation Organization, the PLO, as the occupied state. Now, the agreement stated that for 5 years, the Palestinians will govern themselves, and then Israel would end the occupation and Palestine would have full independence, which never happened. One of the important features in this agreement was that the agreement granted Israel, among other things, exclusive criminal jurisdiction over acts committed by Israel in parts of the occupied Palestinian territories. Now, the occupied Palestinian territories were divided into 3 sections. Area A, which has full Palestinian control. Area B, which has a combined Palestinian-Israeli control. And Area C, which falls under the Israeli control. And Israel has full exclusive criminal jurisdiction there. Now, the Israelis, or those who are in a position of the prosecutor's position, they argue that the Oslo Accords effectively prevented Palestine from delegating its jurisdiction to the ICC. Now, why do they think that? Simply because the Accord prevented Palestine to practice its criminal jurisdiction over Area C. This is absolutely true. The agreement did that. However, here comes the importance of recognizing the difference between types of jurisdiction. It is true that it limited the Palestinian jurisdiction, but it limited the Palestinian enforcement jurisdiction, not the Palestinian prescribed jurisdiction. Palestine still holds its own sovereignty and still can practice its sovereign rights and can absolutely delegate its jurisdiction to the court. As we said, delegating jurisdiction to the court, it's about prescriptive jurisdiction, not enforcement jurisdiction, simply because it's not about the material ability of enforcing jurisdiction. It's about the ability to having the ability as a sovereign state to prescribe laws. Here's the interesting slides, in my opinion. Recently, the court requested Palestine to answer a question. Why the court did that? Because the Palestinian president made an announcement that as of this moment, for Palestine, the Oslo agreements are null and void. because Israel has announced that it's going to annex parts of the West Bank, meaning they will just take parts of the Palestinian territory. And this is against what the Oslo agreements were made about. Now, the court strangely requested Palestine to answer whether it pertains to any of the Oslo agreements between Palestine and Israel or not. In my opinion, this is strange, and I elaborated why I find this strange, simply because, as we just explained, the issue of jurisdiction should not be affected by the Oslo Agreement. It has nothing to do whatsoever with the jurisdiction. Now, the Palestinian response, we will get to the point why the court did that. The Palestinian response was that the statement was not made as part of the record of these proceedings and did not in any way purport to, nor does it legally affect the questions presently before the court, which is, in my opinion, completely true. The Palestinian response further called for the court to act decisively and expeditiously in rendering its decision so the prosecution can proceed with investigations. The prosecutor backed the Palestinian position, saying that the prosecutor does not consider that the statement has a bearing on the status of Palestine as a state party to the Rome Statute and on the exercise of the jurisdiction of the court's jurisdiction in the situation in Palestine. Now, one might ask, why would the court do that? In my opinion, I couldn't see any reason for the court to do that, except for maybe the court, in the judge's opinion, they give a great weight to the Oslo Accords when considering the issue of territorial jurisdiction. And in my opinion, this is a very worrying responsibility. A very worrying possibility, simply because the court mistakenly give a great weight to the Oslo Accords, because it should be irrelevant, in my opinion. And secondly, because if this is the case, then the court itself misunderstands the rule of the Oslo Accords as special agreement and the alleged effect on the court's jurisdiction. The second possibility, which is more appealing to me, I think this is why the court asked this question, because the court wants to guarantee that the recourse to justice is not being used to achieve political expediency. As we explained before, the Palestinians did this before. The Palestinian leadership used the ICC to gain in leverage upon Israel. As I said, this is not a strange thing. This is a normal consequence for any case. There is not one case at the ICC that does not have political aspects in it. But either way, the question, the answer to this question would only be answered by the court's ruling soon enough, hopefully. To conclude, after we explain the two possibilities why the court did that, it's important to always remember that the Oslo Accords, in this meaning as special agreement and in the light of understanding the concept of jurisdiction and the types of jurisdiction, should not have an effect on the court's jurisdiction. And discussing the Oslo Accords at this stage of procedure in particular is irrelevant. Legally speaking, it is irrelevant. Therefore, it would be really interesting to see that the court gives it a great weight. It would rather be very odd, very strange to see that. On a final court, which I concluded my article with, which I also concluded this part in my master thesis, that if the court would decide to exclude any parts of the occupied Palestinian territory, it would be discriminating against the Palestinian people. And this is simply because the texts of the Rome Statute has been never interpreted in this way. If the court to interpret them to exclude any parts of the Palestinian territory, this would be discrimination against the Palestinians and violation of Article 12(3) of the Rome Statute, which states that the applicability of the applicable law of the Rome Statute should be conducted with no discrimination based on sex, color, and national aspiration or origin. Well, this is the end of my presentation. I hope that I didn't take more than 40 minutes. I tried to be on time, and I welcome your. Now we'll turn to Q&A session. Thank you very much for listening. Thank you much for your attention. To you, Tavis.
Thanks a lot, Ahmed, for your very engaging presentation, I would rather say. Students, if any of you have any questions, I don't see that you put any questions in the chat box, but if you want to ask him questions, tell him your name and you can ask the questions. And if you are also allowed to open your video if you want, if the network permits. You know, Ahmed, some of the students are attending from very rural areas, actually, in Bangladesh, and everywhere it is not possible for them to reach or get the correct amount of network to attend it. So pardon them if they don't open their video.
Don't worry, I'm from Gaza myself, so I was born and raised in Gaza, so I had 6 hours of electricity per day, or 3. So not to mention the very bad connection. So I completely understand. And whoever wants to open camera and have a direct connection is also no problem for me. I actually would prefer that. Either way, just maybe send the question in the chat.
Yeah, thank you very much. So anyone, if you want to ask question, please ask your question.
Oh, no questions. Okay.
No questions from anyone?
Well, it could be that it was very clear, and it could be that they didn't understand. So I hope that it was very clear.
Yes, I hope so. I think it should be clear because, but as I also would like to say that our educational institutions opened after like 4 months of lockdown, and we are only allowed to take classes online. They are still missing their campus. Their campus is very beautiful. I would love to invite you to the Geneva University campus, one of the gorgeous, beautiful campus of Bangladesh, you know. Hopefully. So anyone, no, if you don't have any question, I mean, what we can do, Ahmed, if they don't have any question right now, perhaps I can share your email address with them.
Yeah, of course.
Because I have recorded this presentation. What I will do, I will upload it on my YouTube channel only for them, and they can, they can rewatch the video, and perhaps and also go through your slides, and that will give them questions. Or let me ask of like 1 or 2 students if they heard it very well. Mina, can you hear me? Abdul Rahim, Mina? Can you hear me clearly?
Yes, sir, I can.
Did you hear the lecture very well?
Not at all. Your proposal is very right. We can ask question through you or through mail to him after properly watch the video. That will be better for us, if you permit us.
Okay, fine. I mean, I'm not going to put more pressure on them. What about Devjani, are you here with us? I can see you are here, but did you hear the lecture properly? I mean, everything was good? Okay, Ahmed.
Yes.
Let me ask you one question, if probably
Please.
that will trigger some of the questions from them.
Please.
You are quite aware of the situation of Rohingyas in Bangladesh, which is popularly known as Bangladesh and Rohingya Myanmar situation.
Myanmar,
so
yeah.
In this situation, how do you think that this accord, I know you have shed some lights on it during your lecture. So how much would this issue or this situation will be benefited from this accord? I mean, very specific benefits.
I don't quite understand the
the situation is pending before ICC right now.
Yes.
Yeah. So if this situation, because there is some jurisdictional question about this situation, Myanmar is proposing that ICC do not have any jurisdiction on this issue since they are not party, their citizens are not that party. But on the other hand, they are also saying, they are also saying Bangladesh also does not have any jurisdiction to go to the ICC to have remedies for the Rohingyas. So is there any, do you suggest any solution for the prosecutor?
This is, again, this is a jurisdictional issue that was for the first time determined in the Rohingya case, because the interpretation of Article 12, it was, at least for me, substantially established in that case. The court made it clear that the court can assert jurisdiction in the same ways that states can assert jurisdiction, and in this way, for example, if let's say Bangladesh asserts its jurisdiction based on the constitutive elements theory, the ICC could do that as well. In this particular case, the court was clear that it has jurisdiction. There was no question that the court has jurisdiction. For the court, at least, it was clear that the court has jurisdiction. And again, as I said, I think the court has wisely and cautiously taken an expansive approach. The court reflected the compromise reached by states at the Roma Conference in its judgment. I wanted to I'm looking for something in this case that the court, I'm trying to quote something from the court. Yeah, the court made it clear in this particular case that the court's territorial jurisdiction, the court could assert its jurisdiction based on more than one theory. The court said based on the objective territoriality principle, based on the equity principle, as well as the constitutive elements approach, altogether, the court has jurisdiction. Therefore, the court was very explicit, was very clear that the court has jurisdiction, and I don't believe that there will be a problem of jurisdiction in the future. I think it's done. As for the claim from Myanmar that the court does not have jurisdiction, this is the issue of the courts having jurisdiction over nationals of non-state party. For states, the way they see it is, if they are not parties to the court, simply same as the U.S. sees it, same as Israel sees it. If they're not parties to the court, then the court cannot prosecute their their nationals. However, they miss the point that the court does not actually have jurisdiction over their nationals in particular. It has jurisdiction over the conducts, over the crimes. And if their nationals are part of those crimes, if at least if they're part of one element of those crimes, the court would have jurisdiction. Therefore, I don't think this argument would stand in front of the ICC. The ICC was established in those principles. For me, the one missing part of the puzzle was the interpretation of Article 12, and it was very clear in the judgment in this case, in the court's decision. And worth noting that first, when the prosecutor asked the question, the court answered that it has jurisdiction, and that's it. Then when the prosecutor asked permission to start an investigation by Article 15 of the Rome Statute, the court, even though the court could just permit jurisdiction and that's it, the court went all over again and explained why there is jurisdiction. If you read the judgment, the two rulings, you will see that first in Article 19 rulings, the court did not elaborate a lot. The court just stated that there is jurisdiction, and when the prosecutor asked to open investigation, the court went back again to the same issue, even though the prosecutor did not ask the court to do so. The court from itself, the judges, wanted to establish this. And I think such behavior from the court, in my opinion, reflects what I think of as consensus between judges. It's a mainstream idea among judges that this is the way that Article 12 should be interpreted. I think that's why they went back again and they explained it. Therefore, in my opinion, I don't think any jurisdictional argument would have stand in front of the court in this case.
Thank you very much. Anybody I want to ask a question? Do you have any question in mind now? Okay, so if my next question would be very much to help the students of international criminal law. As a researcher yourself and a writer, as an author of different articles and an activist, what do you think should be the future topics of research for a student of international criminal law? What things they should focus if they want to conduct research for themselves?
It's a very hard question. Or if anyways I answer this question, it would be my personal ideas, and I think
that's what I'm looking for.
And I think I shouldn't. No, I think I shouldn't, because I don't want it to be understood that this is what people should do. I think every student should find their topics of passion. They would be passionate about the topic of international criminal law. But generally speaking, and I think this is not only my opinion, a lot of professors think that the ICC itself was thought of as a baby. The baby now is, let's say, she's a teenager. She's becoming young, let's say. In this IG, in this context, what I want to say is that there's still a lot of space. There's still a lot of controversial issues, and only by researching these topics and present the ideas of international law and the professional researches and academic neutral researches that will just say what the law says, the real understanding, adhering to the rule of law, I think would help this court to grow to be a very important one. I think I at least myself, I see the ICC as a representation of what humanity could reach to prevent awful crimes that have been committed before, to guarantee that no perpetrator who committed such crimes should walk away. and such crimes should always be punishable and to find impunity. Therefore, I think it is an important topic, although you see, let's say, big powers fighting the ICC. In my personal opinion, the ICC will win those fights. The ICC is based on a treaty. It has 123 members or more, and I think they're very much determined to keep the ICC, determined to participate in its success, especially European states. To be honest, European states are in favor of the ICC and they're supporting the ICC, and perhaps this is understandable after what Europe has witnessed. It is a must, it is a necessity that we have the International Criminal Court, and it's even more important to support it and make sure that it functions properly.
Thank you very much, Ahmed. So once again, I'm grateful to you that despite of your busy schedule with your PhD and your center, you have time for us. You manage the time. Thanks a lot. And I hope that in the future, some of my students will become your colleague. I personally may become your colleague, and we can do research jointly. And I'm personally interested that if your center and my university can cooperate in the establishment of a law clinic on international criminal law and humanitarian law, that would be a great joint endeavor for Asia, for South Asia as well. And in a nutshell, it will be a great thing if we can collaborate and cooperate with each other for the greater global South.
I think I agree, and to be honest, personally, it's a personal note. I am very much interested in the International Criminal Court in Bangladesh. I think it's also an experience that international criminal law in general could benefit from. As for the cooperations with the KGF and Leiden University, I think we will talk about that. But again, I'm of no position to make decisions. But what I can tell you that talking with Professor Heinsch, I think there is a possibility, and I will put you in direct contact with the center, and I'll be looking forward for further cooperations.
Yes, please do, because me and my students, both all of them are looking forward to working with your professor, the center. And we can start on a temporary basis. Whenever we are in direct contact with your professor, probably we will talk more. We will take it to a greater level. So till then, I will say once again, thank you.
Thank you.
On behalf of my students, I know they're immensely benefited by this lecture, and they will definitely get back to you by email. And if they send their questions to me, I will send the questions to you as well.
Well, thank you for your patience. Thank you for having me. Thank you for the invitation, and it's been a pleasure, and I'm looking forward for further cooperations. Stay safe, and hopefully to see you soon.
Yes, thank you. Thank you. I'm switching off the camera then. Thank you very much.
Okay, bye-bye.
Take care. Bye.